back to the afternoon session. Hope you all had time to recharge your batteries, eat something, drink something. And I'd like to welcome as well Dr. Samantha Currie from Liverpool University, who's visiting here at the Monash European NEU Centre for a few weeks in not long left. And she's going to be talking about the free movement of workers in the EU. Very important topic and one that is directly related to EU structures. So a bit different from what we had before on social policy, which was more at the national level. This is going to be a lot about national issues as well, but also with the impact of supranational policies. And well, without further ado,
thank you. Thanks, Alfonso, and thanks for the chance to speak here today. As Alfonso said, I'm going to focus on the sort of legal and policy framework that governs the free movement of workers or labour migration within the EU. And a bit of an advanced apology in that I teach in a law school, and so I do have a tendency to give maybe too much detail on the sort of legal framework and legal provisions. And those of you that I met last Friday probably realise that already. So I'll do my best to tone it down and skip through the legal detail. But by the same token, I will include some of it because I think the legal framework plays an important part in setting the parameters and setting up the structures that a lot of the policy then comes from as well. Okay, so let's move on. In terms of what I'll focus on today, thank you. I'll start by focusing on the EU law and policy on the free movement of workers as it applies normally, so the fairly standard, well-established rules on free movement. Then I'll move on to the post-enlargement transitional provisions on free movement. So what I want to do is introduce the enlargement dimension and talk about the temporary limitations that are imposed on labour migration after accession of new member states. And then I'll finish by thinking about the potential legacy of the transitional free movement restrictions. So considering whether we need to be concerned that these so-called temporary free movement limitations might actually have longer-term effects on migrants in the EU. So that's my sort of plan for today's lecture. Okay, so here's one of the slides I can probably skip through. I just wanted to highlight the key provision of the Treaty on the Functioning of the European Union that really governs and sets the parameters of the right to free movement as an EU migrant worker. So just to give you a bit of detail on what is included in the provision, you'll see that we have the right of freedom of movement for workers established within the EU here, and then we're told that in order for that free movement to operate, there needs to be the abolition of any discrimination based on nationality between workers of the member states. Okay, so we can see already that when we're thinking about the right to move as an EU migrant worker, a lot of it comes down to the abolition of discrimination, okay, and the right to be treated as a national worker when you move from one member state to another. And we don't need to worry about the heavy detail, but we are given a little bit more information in the treaty article about what that right to move as a worker looks like and what it contains. So we're told that migrant workers have the right to accept offers of employment made in other member states. They have the right to move freely within the territories of the member states for the purpose of work. And an obvious one, but a much needed attached right, is the right to actually stay in a member state for the purpose of employment. And then point D is quite interesting because we see that migrant workers have the right to remain in a member state once employment comes to an end. Okay, so if we're thinking about how free movement works and the rights that are attached to it, There are rights to actually move around, take up employment, but there are also rights to stay in the member states once the employment comes to an end. Okay, and it's important to sort of mention at this juncture that when we're talking about a right to free movement, it applies only to EU citizens, so nationals of the member states, those with nationality in the member states. In order for the law and policy on free movement of workers to actually operate, there has to be an element of intra-EU cross-border movement from one member state to another. And that cross-border movement can come about in one of three ways. So, the first that we can see there on the slide is when we have cross-border movement by an individual for the purpose of both employment and residency. Okay, so this is a sort of typical migration model where the worker moves to take up employment. Aside from that though, we might have the situation of frontier workers, which is becoming more common by all accounts in the literature, where you have cross-border movement, but it only occurs for the purposes of employment. Okay? So an individual might retain their residence in their home member state, but cross the border on a fairly regular basis in order just to take up employment in a usually neighbouring member state. Okay, and then the final type of cross-border movement that falls in this group, so the free movement policy, is where you have the returning migrant worker. So somebody that has exercised their employment rights in another member state for a number of years and then returns home to their home member state. They'll still fall within the scope of free movement law and policy under EU law. In terms of where we look to find out about the rights that migrant workers have in the EU, there are a few sort of key locations. The treaty article we've already had a look at, but there are also some EU secondary legislation. There's a directive and a regulation that fleshes out the detail in Article 45 and gives more concrete rights of free movement to migrant workers. And then importantly, as an additional layer on top of the legal provisions, we have the case law of the Court of Justice, which is really plays quite a significant role in interpreting the provisions of the treaties and the secondary legislation, and adding an additional layer of protection to the rights of those that want to exercise rights of free movement. Okay, and I just wanted to give you a little flavour of why the court's interpretation has plays an important role in this area. What the court has done in interpreting the legal provisions on workers is really broaden the scope of free movement law so as to incorporate as many mobile EU citizens as possible into the framework and enhance the degree of protection available to them. So the court's been really keen to ensure that even individuals who are working very limited numbers of hours, not earning very much money perhaps at all in the host member state, have still been able to gain protection from the legal framework and fall within the scope of the overall policy. So I've just very briefly included details in a few of the key cases. These are old cases now because they occurred at the time when the court was establishing the rules on free movement of workers. But to give you an example of the Levin case, which you can see up there, in Levin you had a UK national that moved to the Netherlands, and she was working, but it was part-time work, only a few hours a week, and the amount of money that she earned was really quite low, so she didn't actually meet the minimum subsistence level of the Netherlands. But nevertheless, the court was really keen to find that she could fall within the scope of the treaty and of the EU freedom of foreign policy and benefit from the status of being a migrant worker. And that's a trend that we can see in the case law right the way through. So, to give another example, we have Kemp, and Kemp was a German national, again in the Netherlands. He was a music teacher and only worked about 12 hours a week. Again, he wasn't earning very much, and he was relying on the Dutch social security system in order to supplement his income. But again, the court didn't think that that was a bar to him qualifying as a migrant worker and gaining the protection of the overall legal framework. Okay, so just a couple of examples out of a whole raft of case law on the free movement of workers, which hopefully demonstrates how the court has been keen to be quite generous in opening up the available protection. In terms of the actual rights of migrant workers, the first we've already mentioned, and quite an obvious one. They have a really secure right of entry and residence into other member states. So if you're an EU citizen that wants to exercise the right of free movement by taking up a job in another member state, the host member state is really limited in any kind of sanctions or limitations it can place on you. You have really quite secure rights of entry and residence. What's more interesting, though, is the scope of the rights that the migrant workers can access once they're actually in a host member state and working. And the most important entitlement that the migrant workers have is a really secure right to equal treatment with national workers. And this right to equal treatment can have implications in different areas of their lives. So they essentially have a right to be treated as a national worker. That applies when they're seeking to access a job, so going through application procedures to actually find work, and it also applies once they've actually managed to secure a job, so that everyone again applies to the ongoing exercise of that employment. So you'll see there that the sort of prohibition discrimination or a right to equal treatment, whichever way you want to sort of phrase it, and it applies to both the taking up and the ongoing pursuit of employment in the first state. And the type of discrimination that it prohibits is very broad. Okay? So it applies to both direct and indirect discrimination. Okay. And to give a little bit more detail and flesh out a little bit about how this right to equal treatment could be really beneficial, I just wanted to highlight one of the most important examples of that right to equal treatment. Okay, and it's found in the regulation on workers, and it's this provision which says that migrant workers can enjoy the same social and tax advantages as national workers. Okay? And the key phrase there is social advantage. Okay. And the reason that this has been so important is because of the interpretation that has been given to the concept of social advantage. So it's been again interpreted really broadly by the court to encompass a whole range of social and welfare benefits, even though it's not connected to the actual exercise of employment itself. Okay, so if we're thinking about the practical impact of this, it means that migrant workers in the EU are able to access a whole range of different social benefits and welfare rights once they've reached that stage as qualifying as a migrant worker. It's a really valuable right for them to have and be able to exercise in a host member state. Particularly if we think about what I mentioned earlier on, that you don't even need to perhaps be earning very much or working very many hours before you reach that stage of having qualified as a worker. So the rights that are attached to workers are really quite secure. To move on a little bit then, I want to introduce the enlargement dimension. So we have all that background on the free movement of workers, which looks very generous. We said that the court has interpreted the rights of workers very broadly, so they have this really secure status. But when we introduce enlargement, and particularly the accession of a number of member states with perhaps poorer performing economies and higher unemployment rates, the debate and the tensions that arise around the whole idea of labour migration and free movement alter a little bit. And we saw this particularly with the accession of the 8 Central and Eastern European member states in 2004, and then again particularly with Romania and Bulgaria in 2007. So these accessions pose challenges to the operation of free movement law and policy. And just to give a little bit of a flavour of the statistics and figures that were floating around at the time that influenced the debate, there's a couple of points about the scale of the enlargements first of all. So you can see that the 2004 Big Bang enlargement increased the EU's population by 28% all at one time. So we had 500 million plus new EU citizens created. And then in January 2007, the population increased again by a further 29 million. And clearly these figures are now quite old, but they were really relevant to the 2004 accession process. You can see some of the differences there between the monthly minimum wages in some of the accession member states as compared to the UK and France as older member states. So clearly quite significant economic differentials that influence the debate. Okay? So, the concerns of the older member states around the issues of labour migration and the extension of free movement rights centred on the possibility of labour market disruption as a consequence of quite large-scale movement, as they foresaw it, into their territories, along with concerns about social dumping and welfare tourism. Okay, so the way in which free movement law and policy operates, as I've very briefly sketched already, was thought to allow particularly welfare tourism. Okay, because we've seen that we have a court that's been keen to protect those that may not actually be earning very much in a host member state. And a lot of the older member states were very concerned that we would have people moving, not earning very much, but then seeking to access quite a lot of social benefits from the welfare system. Okay, so because of those concerns and a lot of the fears, even those that turned out to be completely unfounded, we had transitional arrangements on free movement, and they were negotiated into the 2004 accession treaties, and they've been negotiated into all of the accession treaties since. So those that apply to, obviously, most recently Croatia, and those that apply to Romania and Bulgaria. In terms of how the transitional arrangements on free movement operate, okay, well, they allow the old member states to derogate from the law on policy on free movement of workers in respect of the new EU citizens. Okay, so essentially the older member states are allowed to limit labour migration from the new member states, and they can do that for a maximum period of 7 years. These restrictions only relate to labour market access, okay, so they don't apply to any of the in-work benefits that I sketched earlier on. Okay, so that just means that those of the older member states that do decide to open up the labour market, they shouldn't then seek to impose any restrictions on the type of benefits that the workers can receive. Okay, they're only entitled to limit access to the labour market. The new member states can retaliate with reciprocal measures. UK, and they tend to. So those newer member states that do find themselves at the end of restrictions tend to introduce their own reciprocal measures to limit the movement of individuals from the older member states into their territories. And even those member states which themselves still experience transitional arrangements, they can still implement them against newer member states. Okay. So when Romania and Bulgaria acceded in 2007, member states like Poland and the Czech Republic, even though they themselves were still at the receiving end of their transitional arrangements, they could still choose to impose them against the newer member states. Okay, in terms of how they've been implemented, after the 2004 round of enlargement, we could divide the member states up into a few different camps in terms of how they decided to implement free movement restrictions. So Germany and Austria were the most ardent supporters of transitional arrangements, influenced particularly by their geographical proximity to a lot of the exceeding newer member states. So they imposed labour market restrictions immediately, and they did so for the full 7-year period. Okay. After Germany and Austria, we had a sort of flock of other member states that followed the trend towards protectionist measures, but they did so fairly late on in the process as May 2004 approached. So we had a bit of a domino effect with a number of member states following one another and implementing restrictions quite late on. The UK did open its labour market after the 2004 accession process, so it did allow labour market access, but it did introduce some changes to the social benefit system. The compatibility of which with EU law is questionable, but it's probably beyond the scope of this talk here to go into the detail on that. But nevertheless, the UK did open up its labour market, and Sweden and Ireland opened their labour markets. So, as we're talking about the 2004 enlargement here, the transitional arrangements expired in 2011. That was the end of the 7-year period. So from that point onwards, we've had free movement law applying normally. In terms of Romania and Bulgaria and their accession in 2007, in the years between the two enlargements, there's clearly been a change in the economic performance and success rate of member states like the UK. Okay, so the UK economy had changed quite dramatically for the worse, and unemployment levels had risen quite considerably. And that really influenced the UK's decision this time to implement transitional restrictions and to prevent free movement of workers, of Romanians and Bulgarians. So Sweden was the only of the older member states to grant immediate labour market access after 2007. And Hungary was the only of the EU 8 member states to impose restrictions on EU2 nationals. And what a lot of these national measures did was to close off the normal routes of free movement, but to allow movement of Romanians and Bulgarians when they could access a work permit. So we did tend to be looking at work permit restrictions. Finally, in terms of Croatia, you can see that the member states that currently are applying transitional restrictions against Croatia. So it's still fairly heavily dominated by older member states. We also see Slovenia and Cyprus and Malta as current imposers of transitional restrictions for Croatian citizens. Okay. In terms of how we might reflect on the existence of transitional arrangements in general. We can't ignore the impact of the economic recession on the debate, as I've already mentioned in the UK context. There is an inevitable move towards protectionism when times get tougher, and we can see sort of the difference even between the 2004 and 2007 rounds of enlargement. More broadly, I think we need to be concerned about the impact that transitional arrangements have in undermining the status of union citizenship. Free movement is really one of the key rights that EU citizens have from the EU. So restricting the right to free movement really undermines the package of entitlement that individuals can access as a consequence of their EU citizenship. And around the 2004 accession, there was a lot in the literature about how free movement as a right was viewed particularly importantly by citizens of the Central and Eastern European states that had previously experienced quite stringent restrictions on free movement under communism. Okay. So to cut off that most valuable of rights really does, I think, undermine that status of union citizenship. A sort of separate point from that then is that transitional arrangements are seen as being beneficial for the older member states in that it gives them a greater control over access to the labour market. But there is evidence in the empirical research that's out there that actually all the transitional arrangements do is divert workers into the shadow economy. So individuals tend to move anyway, and if they can't do it through lawful routes, they may end up entering a member state by irregular means or working irregularly in the member states. And in that case, the older member states may actually be putting off their noses to spite the face, because they then lose out on tax and national insurance contributions. There's a sort of supply and demand sentiment embodied in the transitional arrangements as well, with newer member state nationals being treated like a sort of flexible reserve army of labour, only to be called upon when the older member states require them. And that sort of use of the new citizens has an impact also on non-EU nationals. And to give a little example of what I mean by that, taking the UK context, certain sectors-based schemes, like we have the seasonal agricultural worker scheme in the UK, that scheme was previously open to all nationalities, and following the 2007 round of enlargement, the UK government directed that scheme only at Romanians and Bulgarians. So then there was this sort of knock-on effect for their country nationals, non-EU nationals, who then lost the opportunity to take part in that scheme. Okay, so there is this sort of larger knock-on implication of the transitional arrangements for migrants more generally, not just those that are affected by the transitional arrangements directly. Okay, and just finally then to think about this idea of the legacy of these transitional arrangements. These transitional free movement restrictions are now firmly embedded in the psyche of the EU. And I think we've seen this quite recently with the 7 years expiry of the Romanian and Bulgarian restrictions ending in January this year. So all member states were required to lift free movement restrictions as regards Romanian and Bulgarian citizens this year. And I just noticed a typo there, it says 2013 when it should say 2014. So apologies for that. However, there's been a reluctance on the part of some of the older member states to relinquish these restrictions and to embrace free movement law proper, as we sort of discussed earlier on. And in the UK, there's been a really distasteful debate around Bulgarians and Romanians working in the UK. It's been promulgated by the media, but it's also been promulgated by politicians as well. Okay, so there's sort of been lots of reports about exaggerated levels of migration from Romania and Bulgaria that so far haven't materialised. And also about the so-called work ethic of the workers, criminality, and so forth. And this sort of tendency to phrase free movement rights as regards these citizens in such a negative light isn't going away despite the expiry of the transitional arrangements. So most recently, sort of in February, just before I left, the UK government had put in place plans to introduce an earnings requirement on EU migrants. And as I left, the details that they would include an earnings requirement of £150 a week on anybody seeking to qualify as a migrant worker under EU law. In terms of how that would work, it would apply to all EU migrant workers, okay? Though it's clearly, the development of the policy has clearly been motivated by fears about political restrictions for Romanians and Bulgarians. Significantly, it would blatantly contradict EU law on free movement, which, as we've already seen, has avoided the imposition of earnings requirements on migrant workers. And this suggests really that enlargement, and specifically the transitional restrictions, may have ongoing implications for the free movement of workers in the EU. Okay, and I think one of the most worrying things about it is that you have these transitional restrictions, which is seen as a temporary measure to expire after a certain period of time, and that everything then goes back to normal. But I do think that we have this sort of potential for a race to the bottom with the free movement of workers, and it could have quite significant implications for an area of EU law and policy that has operated in a well-established way for a significant period of time. And it would have implications, clearly, not just for migrants from newer member states, but it would have implications for all EU migrant workers. And then we also have the sort of final point would be that we're in an interesting legal position now, because if more member states seek to follow the UK's position and impose restrictions outside the scope of the transitional arrangements, that raises lots of interesting legal questions in terms of how the Commission would respond, and whether we would see enforcement proceedings before the Court of Justice to challenge some of the restrictions. Certainly, if the UK goes ahead with this policy, we would expect the Commission to make initially some kind of statement and to get involved in the overall situation. So I'll leave it there rather than chatting on any further. Any comments or questions, I'd be really happy to take them. So thank you.